Hello and welcome to this new video. Today I'm going to be reviewing Lexis. So in the last two videos, I took a look at mid-page, which I believe is a great tool for attorneys or law students trying to streamline their research on a particular legal question. So with that being said, let's go ahead and turn it over to Lexis AI and let's see how it does on the same question we already looked at in one of the mid-page videos. So here I've given it the same prompt I gave to mid-page and that I gave to ChatGPT, and let's see how it's doing. Hmm. Okay, so my prompt mentions the Brady versus Maryland case. We're talking about the Brady right again, extending to um, pre-plea agreement. Okay, is the defendant entitled to material exculpatory evidence? Now, what we got from mid-page was the Alvarez case is what came up as a search result. What we got from ChatGPT was, I believe it was the McCann case. It was one of the circuits that was in favor of extending this Brady right to pretrial. But here, what we're getting is Alvarez, which is, again, as I've previously noted, the most important case on this. We also see the McCann case here. That's also very good. Mansfield, I don't know that I'm familiar with. Oh, yeah, Mansfield is the newest case in this line from, I think, 2022. And again, Supreme Court denied cert on this again. Um, Ruiz is an extremely important case. It's probably the most recent case in the progeny of Brady that we can extrapolate from. So I'm glad it's included. And yeah, I'm very impressed with this. Okay. Um, the fact that it's got Alvarez, which in my opinion is the most important case because it talks, there the court, it's en banc in the Fifth Circuit, and they discuss circuits that have found similarly and circuits that didn't, and it kind of debunks the circuits that did not. So, and then on top of that, the most recent case, and then McCann. I don't know that. I guess McCann is the yeah, McCann's a good case to find for the other side. I also would have been happy to see the O'Leary case or the Smith versus Baldwin case, but this is good. All right, now let's actually start reading into this. Defendants have a due process right, do have a due process right to access material exculpatory evidence before entering a plea agreement. Okay, that's wrong. This right's rooted in principles established by the Supreme Court in Brady versus Maryland, which requires prosecution to disclose. Did I say something in my prompt? No, I stayed objective of whether or not they do. Where the courts have interpreted. Okay. So again, I mean, they should not be saying that affirmatively there is. Arguably, everything is going against that. It's rooted in Brady versus Maryland, requires prosecution to disclose evidence favorable. Yep, yep, yep. Um, and then it it cites Alvarez and Mansfield and McCann, but what these cases talk about is Brady, but they don't say that this goes to the pretrial. Um, yeah, and McCann, I'm trying to think. There's something wrong with McCann. I don't remember what it is, but let me just refresh my memory real quick. Let's go ahead. It's near the end. In McCann, Rui's significant distinction. Yeah, the Seventh Circuit says we need not even resolve this question about, this Brady question because the plaintiff did not present evidence that the defendant was aware. So even they acknowledge the existence of this question, but don't really go to presume it. I mean, I guess anyway. So that's just one of the flaws that I recall with McCann that was pointed out by the Fifth Circuit. Um, And the fifth is clearly disagreeing with it. Sorry, wrong page. Gosh, I'm lost. Um, there it is. So anyway, this is just a terrible first paragraph. Brady decision emphasizes that suppression of such evidence violates due process irrespective of good faith or bad faith. Okay. Did they realize that we're talking about pretrial for entering into a plea agreement? Several courts have interpreted the right to extend to the plea negotiation stage. Fifth Circuit noted that multiple states have held it does apply. It's so funny. I mean, the Fifth Circuit is saying it does not extend, and then they affirm that in Mansfield. They address the circuits that do. Okay, state Supreme Courts. Okay, maybe that is the case. State Supreme Courts. I was more focused on federal, like, maybe that's the case. There's some Texas Court of Criminal Appeals, as long as held that before a guilty plea is entered. Fifth Circuit in Mansfield also recognizing that system is not definitively ruled. Yeah, I mean, I feel like you start with this. It's not definitively ruled. The court held that due process is not required to disclose impeachment evidence before a guilty plea, but it did not explicitly address exculpatory evidence. Similar courts have interpreted Ruiz to suggest that it must be disclosed, especially when it pertains to factual innocence. I mean, okay. Um, the Mausu case. I think, yeah, this is Fourth Circuit from 2010. I mean, this is a noteworthy case on it. Yeah, Fourth Circuit, 2010. I just remember this case was pretty nuanced. I won't go into it here. Recent case law reflects a trend towards recognizing the necessity of disclosing exculpatory evidence before plea negotiations. For example, the Seventh Circuit in McCann, that they would likely find if prosecutors failed to disclose evidence. Actually, but they said they weren't resolving it. This is clearly dicta, wasn't holding. Um, Fourth Circuit must also acknowledge the ongoing debate. What did they say about Mansfield? Also recognize requiring is consistent. No. Fifth Circuit recognized requiring disclosure of exculpatory evidence before a plea is consistent with Brady's rationale, due process principles. I mean, they don't end up applying that if they did have a conversation about it. I know the dissenting opinions write about what a shame it is and that it should. They kind of lament the situation that they're in, but that the law is what the law is. So you're kind of just giving us the feel goods. You're just giving us the feelings of the judges, but I didn't ask for that. I asked for the law. Like they might have in the dissenting opinions noted this. I don't know. Um, Maybe if I go and I read it more carefully, I'll see that they're acknowledging it's consistent, but yet that's not how the law applies. I mean, Mansfield is not a good case for extending Brady. Okay. Recent cases reflect a trend towards, yeah. Wait. Okay. This is ridiculous. I think this is full of inaccuracies. It does give you the most relevant cases, though. So for whatever that's worth, that's what you're going to get with Lexis. Um, And you're gonna have to read these cases really damn carefully because I don't think they're saying what Lexis says they'd say. Um, Now, of course, I didn't look at it through the lens of state Supreme Court's decisions. I'm more focused at the circuit level. So, maybe Alvarez did discuss state Supreme Courts going that way, but it doesn't matter. It doesn't matter. So anyway, I think it's totally just incorrect in how it's using some of these cases. So I'm going to say this is bad legal analysis, but good for finding cases. And we'll just leave it at that. Thanks for tuning in. I hope you enjoyed it. Subscribe, like, whatever. More videos coming. Bye.